When an agency creates a new rule, it must comply with the Administrative Procedure Act's notice and comment procedures. That is, unless the agency doesn't have to comply with notice and comment procedures. The court in Metropolitan School District versus Davila reconciled these contradictory statements and answered whether interpretive rules are exempt from the Administrative Procedure Act's rulemaking requirements. In 1990, Congress passed the Individuals with Disabilities Education Act, known as IDEA. The Office of Special Education and Rehabilitative Services, a federal agency, administered IDEA. Robert Davila was the assistant secretary at the agency. The director of special education in Ohio wrote a letter to Davila asking whether a section of IDEA, known as IDEA B, required states to provide education services to disabled children who were suspended or expelled from school for reasons unrelated to their disability. In response, Davila wrote a letter explaining that, based on legislative history, the agency determined that Congress wanted states to still provide education services to the students in question. Therefore, the agency interpreted IDEA B as requiring states to continue to provide education services to students who were suspended or expelled from school for reasons unrelated to their disability. The agency's interpretation of IDEA B, as stated in Davila's letter, wasn't published in the Federal Register or the Code of Federal Regulations, and it wasn't subjected to a public comment period. The Metropolitan School District for Wayne Township, Indiana, sued Davila on its own behalf as well as on behalf of other school districts that provide educational services to disabled children. The school district argued that the agency's interpretation put a large financial burden on school districts. Also, the school district argued that, under the Administrative Procedure Act, the districts should have been given notice and had the opportunity to comment on the agency's interpretation or proposed rule. The school district and Davila both filed motions for summary judgment. The district court held that Davila's letter explaining the agency's interpretation of IDEA B was a legislative rule, so it was subject to the Administrative Procedure Act's notice and comment requirements. The court granted the school district's motion for summary judgment. Davila appealed.